Hello, welcome to Inside Area 9. I'm Kathy Bridgford and I'm your host today, and I'm with the Area 9 In-Home and Community Services Agency. Today we're going to be talking about a very important topic, estate planning. As we grow older, we really need that, and my guest today is Doug Oler. Doug, thank you for coming today.
Thank you for inviting me.
Sure.
It's nice to be here.
Sure. And you're with Boston Beaver Cling and
Cross and Chittister.
Cross. Okay. I get my tongue twisted when I say all them. And you specialize in elder law.
Correct.
And we don't have a lot of those in the area, so I really appreciate you coming
nice to be here.
and talking about that. So tell us, what is it and what does it include?
Estate planning has probably two definitions, a broad definition and a narrow definition. The narrow definition is planning the disposition of your estate, your assets at death. It's usually done through giving instructions in your will how you want to dispose of your assets, who you want to give your assets to, how much you want to give them, when you want to give it to them. And as I said, it's done at the time of your death in a will. The broader definition of estate planning is it encompasses more than what happens at death. It encompasses planning during your lifetime, such as do you want to make gifts? Do you want a living will to take care of the situation where you're in a terminal condition, or do you want to have power of attorneys to take care of the situation where you're disabled? So it has a narrow definition and a broad definition.
Mm-hmm, mm-hmm. Okay, well, how would I get started to plan my estate plan?
It's a good question. I get asked that a lot. In fact, I've written an article that's on our website. I'll put a plug in here. It's the website is bbkcc.com, and if you go to the website, there's an article there on this topic.
Okay.
Basically, I say you need to, before you see the attorney, do probably four things. The first step would be to assemble your documents. Do you have existing wills and power of attorneys? If so, assemble those. That sounds easy, but I have had a lot of situations where people can't find their documents.
Oh, I can imagine.
Their will, for example. They know they had one, they can't find it. But that's the first step, is get control and find your documents. It may be deeds, it may be power of attorneys, it may be wills. The second step would be to list your assets, do an inventory of your assets. That sounds, again, simple, but it involves making a list of everything you own: house, cars, bank accounts, IRAs, collectibles, and even more important than that is how those are held. Are they held in your own name? Are they held in your spouse's name? Are they held in joint name? That's important. For example, if you have a joint asset, your house is in joint name, the house is going to go at your death to the surviving spouse. It doesn't go under the will. So it's really important for an estate planner to know not only what your assets are, but how they're held. The third aspect of getting started would be then giving family information, such as your children. How old are they? If they're minors, for example, that may trigger a thought to do some more planning, maybe with a trust or something like that. Do you have special needs children? That's a big area right now. There's lots of people out there with special needs, and so we need to know that history. Do you have an interest in giving certain assets to certain children, for example? And the fourth step is, what are your goals? What are you wanting to accomplish here? Is it merely just to pass on your assets to your spouse and then your children? Or do we want to go deeper and, again, look into special needs of children? Do we want to include grandchildren as well as children? Do we want to go to that second generation even? Those are things that it's important to know too. So there's four steps there to get you started. Once you collect your documents, once you inventory your assets, once you put down the family information and you know your goals, I think you're ready to go to the lawyer. And if you have all that information assembled, it's going to save you time at the at the lawyers and save money as a result. That's how you get started, I think.
That's how you get started, okay. And I could see that being a chore in some families. You know, some families,
It is
like
a
you
chore.
said, they can't find documents. I've been in, you know, being at the area agency, we've been in a lot of elderly homes, and sometimes things are just everywhere.
I had a lady one time that knew her husband had a will, but it was 6 months just finding the will,
it.
and she went through a lot of stress. And, so it can be more complicated than it
Yes,
sounds.
I bet. Now, when you were talking about the documents, what documents would you be referring to?
Typically, in a normal estate plan, you start with the will.
Okay.
That's the foundation.
Okay.
Then you have a general durable power of attorney, and then a healthcare power of attorney. And some people now, or not some, many people now are wanting living wills. And then the fifth document may or may not be applicable, and that's a revocable living trust. That's probably a subject for another program.
Probably.
But it starts with those basic documents.
Okay. Okay. Well, you've mentioned these documents in order to get a plan, to get your plan. Why don't we look at those documents
Okay.
in a bit more detail?
Fine.
So you've got the last will and testament, correct?
Correct.
Okay. Why do I need a will and a last testament?
Another good question. Lots of people statistically do not have wills. I think it's really high, 60 or 70% actually, do not have wills. But the main reason for a will is that if you don't have one and you pass away, the state of Indiana has a statute that says what happens to your assets. That statute may not dispose of those assets the way you want them disposed. So you want a will to say what you want done, not what the state of Indiana statute says. That's the primary reason to do that. For example, you just take a husband and wife and 2 children. If the husband dies without a will, the state of Indiana's statute says that part of the assets go to the spouse and part go to the children. That's probably not what the spouse wanted, the husband wanted. He probably wanted all those assets to go to the surviving spouse.
Even
first.
if the children are older.
Right. So it's important, the main reason is to have a will. To have a will is to override that state
Yes.
statute.
Yeah. I'm sure a lot of people don't realize that. You know, even if you don't have a lot of assets, but maybe just your home or whatever, just a small amount, that's important.
Another reason, probably a less important reason, would be you get an opportunity to select who you want to be, if you have minor children, who you want the guardian to be. You can select who you want the executor to be. Again, if you don't have a will, you've missed that opportunity. So, but the main reason is to avoid that Indiana statute.
Okay, okay. Well, what's the requirements to have one?
There's, again, about 4 basic requirements. One is you have to be age 18. 2, you have to have the requisite mental capacity, and that may be a whole nother topic too that we can talk about. And 3, it has to be in writing, and 4, it needs to be witnessed by 2 disinterested parties. Those sound simple, but sometimes they turn out not to be. People have their wills witnessed by one person, for example, or they'll have it witnessed by a person who's a family member. We want somebody disinterested.
Yes.
And so going to the office store and buying a canned will sometimes misses these requirements. So you have to be really careful if you're going to do that. I don't recommend it, but I'm biased. Those are the main requirements. And the tough one there is capacity, mental capacity. Do they have that requisite capacity? And sometimes that's extremely difficult. I always say that if there's a question, I want a medical statement, doctor statement, saying that they would understand the nature of what they're signing. But mental capacity is a tough issue.
But it is. So after I sign it, then what do I do with it?
You probably have 2 or 3 choices. One is you could leave the original with the law firm. We have a vault, for example. We can keep them in with no cost. Or you can take them home. I don't encourage that unless you have maybe a fireproof safe or cabinets at home. Or you can put them in your lockbox if you have a lockbox at the bank. Those are probably the 3 safe places to keep them.
Somewhere where somebody can find it, right?
Correct. That's right. If they're in that lockbox, sometimes it's difficult to get into.
Yeah. Okay. What if I want to change it after like a year or 2 down the road?
The will can be revoked. It can be amended.
Okay.
We do it what we call with a codicil. That's a fancy legal term, I guess, for amendment. But as long as you have the mental capacity and it's witnessed properly, you can change your will at any time. You could write a new one every day, I guess, if you wanted to.
Okay.
I recommend that.
Okay, yeah. Keep you busy. Huh?
Right.
Well, you mentioned earlier about the durable power of attorney. Why would I need a power of attorney?
Well, let me back up. There's 2 kinds of power of attorneys,
Okay.
the durable power of attorney and the healthcare power of attorney.
Oh, okay.
You ask about the durable power of attorney. That is for the situation where you're still living, but you're incapacitated.
Okay.
In that circumstance, if you don't have a power of attorney, the only alternative and a decision needs to be made, like paying bills, selling a house, or something like that, and you're incapacitated and you do not have a power of attorney, our only option left is getting a guardianship. That's a really cumbersome, awkward, costly process because you have to go to the court, ask the court to declare that person incapacitated, and ask the court to name you or somebody as guardian. The court does not do that just willy-nilly. They take that very seriously, and so it's a time-consuming process for the court to make sure that that individual is incapacitated before they'll implement the guardianship. So the only way to prevent that is to have a power of attorney. It's a pretty simple document that's not that expensive, and so it's well worth it. What's happening is people are living longer. As they live longer, the odds of incapacity increases. And if you wait too long and you're incapacitated, you cannot sign that power of attorney. So, but the main reason for the durable power of attorney is to avoid the guardianship statutes and allow us to get to perform services for that incapacitated person.
Who would I want to give a power of attorney to?
Most times people use somebody in the family. I recommend if you're going to go that route, it would be somebody that you have a great deal of faith and trust in, because they could be handling all of your assets. Probably the famous case where that went wrong was the Groucho Marx. Everybody's probably heard of Groucho Marx, except you're too young for that. But he named a caregiver. And over the next probably 5 years of his life, the caregiver took advantage of him, and Groucho ended up at death with being penniless because he named the wrong person. So that's a good question, and you really need to give some thought to who that is. It could be an independent, doesn't have to be a family member. It could be an independent person that you know and trust. It could be a bank, for example. They're very capable of handling the assets and income and paying bills. They're equipped to do that. So it could be any one of those. I would say that if you have disharmony among your children or among your family, it might be wise to go to an independent third party, like a bank. They take the emotions out of it. So I kind of look for that before I recommend who. Do I sense disharmony there or not?
Can you give to more than one person?
Yes.
Okay.
Legally you can. You can have 3 or 4, whatever, but I wouldn't recommend that. The more you have, the tougher it is to get agreement
I bet so.
In fact, there was a judge here in Wayne County at one point even though it wasn't in the statute, he just flat out wouldn't.
Yeah. Trouble down the line.
Appoint more than one or two people. So you can, but I don't recommend it.
I can understand that. How long do they last?
General durable power of attorneys, that's how they get their name, durable. They last forever until death. Once you pass away, that power of attorney ends and the executor under the will takes over.
Okay.
So general durable power of attorneys will last. They got the name durable because once you become incapacitated, they still are in effect, still valid. So that's why we call them that. They're durable, they last past incapacity. So they can last forever.
Okay. We were talking about, the bank or a family member what would be the requirements? Just over 18 or?
You have to be over 18, has to
Okay.
be in writing. And I'm glad you asked that because the POA has to be notarized, not witnessed. I had one just come in the other day and they went to an office supply place and they had it witnessed instead of notarized. So again, you got to keep that. That gets confusing for people. Wills need to be witnessed by two people. Power of attorneys are notarized by one person.
Okay. Okay, that's a big difference. So
Yes. Yes.
when it comes down to the
Right.
legal
Right.
end of it. Can you have more than one attorney, in fact, with being the general durable
Yes.
power of attorney and the healthcare power
Yes,
of attorney?
you can. Yes.
Okay.
They can. You can have multiple. We call them attorney-in-fact power holders for both the healthcare and the general durable power of attorney. And the power of attorney-in-fact can be different than the healthcare attorney. I've had situations where they've had one of their children's a nurse, for example, and they want that child to handle the healthcare decisions and maybe the other child to do the business decisions. And that can be done.
That makes sense. That makes sense.
And it works out well that way.
Yeah, okay. Well, let's talk about the healthcare power of
Okay.
attorney now. How is it different? What's the difference between them?
Well, the healthcare power of attorney is a document, again, that says if you're incapacitated, you appoint somebody to make healthcare decisions as opposed to business and financial decisions. Strictly healthcare. That could include power to sign for surgery, power to get to place somebody in a nursing home, power to get medical records. All of those things fall under healthcare. And so the healthcare power of attorney is really important because, again, people, as they become incapacitated, have health and care needs. And so we need that document. Hospital will ask you when you're admitted, do you have a health care power of attorney? Do you have a living will, for example? And we'll touch on that, I know, in a minute. But that's the difference between the durable power of
Okay.
attorney and the health care power of attorney.
Okay.
Have to be executed the same, well, you have to be 18, you have to have it notarized. So
Okay.
basically the same
Pretty much the same.
requirements.
Okay, so would you have more, well, I know you said you could have more than one person, but you didn't recommend it on the durable power of attorney. What about the healthcare representative? Would that be a little more likely to have two people on or not?
Perhaps it just depends on the family dynamics.
Okay.
Obviously, a third party or a bank, for example, does not want to be
right,
a healthcare power
yeah.
of attorney. They'll handle the business decisions, but they don't want to make the personal decisions that are involved in healthcare decisions. But family members, it just depends on the dynamics there. If there's cooperation, then I have no problem with two. If I sense disharmony, I just discourage that again. But legally, you can have.
If you had two, do you have to have both of them say to the doctor or to the hospital, both of them, or can one? Or is that getting too
And that's a
specific?
problem sometimes because nowadays families are all over the country.
That's what I was
One can
thinking.
be in California, one
Right.
be here, and one can be in New York. And so that can be a problem. However, it's not as big a problem as it used to be now with emails, with overnight mail, faxes.
Okay.
We can communicate a lot better.
Yeah.
But it still can be an awkward situation if there's miles of distance there apart.
Yeah. Okay. You had also mentioned the living will, or we were talking about that. What is a living will?
People get a little confused with that. What's the difference between a will and a living will? A last will and testament disposes of your assets, gives instructions on what you want done with your assets at your death. A living will in Indiana says that you have to be in a terminal condition before it kicks in, as determined by a doctor. Doctors are hesitant about saying that somebody's terminal. You could have cancer and not be terminal. You could have heart disease and not be terminal. You could even be in a coma and not be terminal. So doctors are hesitant. But once a doctor says that you're in a terminal condition, then you say in the living will, I do not want to be on life support. If I'm on it, take me off. If I'm off of it, don't put me on life support. So the living will is for the narrow situation where you are terminal and you're giving them directions to not put you on life support. That's a totally different concept than the last will and testament. The living will does not dispose of your assets. In Indiana, as I said, it's pretty limited because you have to be terminal before it applies.
Okay. Are all states differently then?
Yes, and not all states have living wills, believe it or not. Last I looked, I think there was 35, 40 states had living wills, and each state is different. That can present a problem. People are mobile. We have a mobile society, and as they're going to Florida or traveling, and they're in an accident, does that living will apply in that state? The answer may be no, it may not be. I have clients who reside maybe 6 months in Florida and 6 months in Indiana, and so I encourage them to have a living will here in Indiana and one in Florida. You could get caught in that situation where it didn't apply.
Okay. What about, you hear on the news people being in comas and the families fighting over, some of them have been made very public, fighting over to keep the child alive or the
There was
person.
a famous case in Florida several years ago, just like that. In this case, that case was I think it was a 24-year-old girl who had just married. She was in a car accident and was in a coma. And the husband and the mother and father were fighting over what the daughter really intended. That the husband said, she told me many times she wanted to be on, she didn't want to be on life support. Mother and father said, yeah, she does. I think we need to keep her alive to see if she could recover. So that case went all the way up in the court system and was really a tearjerker because all this time she was in a coma and there was a lot of emotion at that point.
So she'd had a living will in the state where she was
Most
at.
24-year-olds don't think about becoming incapacitated or dying.
Oh, no.
And so she was very typical 24-year-old.
Yeah.
She didn't have a living will. And so they left her on.
Yeah. But if a person had one and the family fought, the document would
take precedent.
Take precedent.
I had an interesting case not too long ago. A husband and wife come in and I asked them if they wanted a living will, and they apparently had not talked about this ahead of time. And husband said, yeah, he wanted one, and she said, no, I don't want one. And they looked at each other like, where did that come from? Well, it turns out that she had had near-death situation 2 times, been administered last rites by the church, and she had a different perspective. Her perspective was, I beat this twice. I think I can, if you keep me going here, I think I can beat it. And she just had a different perspective.
Right.
I didn't argue with her on that. She looked at it differently.
Yeah. Well, we're just about out of time. Is there any last minutes? We've only got about a minute left. Is there, or should we move on to the next show?
Well, one thing real quick, there's some good news in the tax area. Indiana last year in 2013 abolished the Indiana inheritance tax. We used to do a lot of estate planning to avoid Indiana inheritance tax. We no longer have to do that. Effective in January 2013, there is no longer any Indiana inheritance tax.
That is good news. That is very good news. Well, thank you so much for coming today. And can you give them that website again?
It's bbkcc.com.
Okay.
Thank you.
Okay. And look that up. And thank you so much for coming today, because it is such an important topic. So. Thank you all for joining us today on Inside Area 9. And if you'd like more information, you can contact Doug Oler or go on his website and look for the things that you need to get ahead of time before you see your attorney. It'll make things much easier for you. And again, thanks for joining us today, and we'll see you next time on Inside Area 9.